right, we'll go ahead and get started with a few introductions, a little housekeeping, and take care of a few of those pieces while people are still coming in. Good morning, I'm Nancy Williams with Buncombe County's Community Development Division, and I'm really thrilled that we are able to host these fair housing trainings today. We have our partners, the City of Asheville, Homeless Strategy Division, who is one of our partners and sponsors for this, along with the Land of Sky Council of Government, which covers 4 counties, Transylvania, Henderson, Buncombe, and Madison. So hopefully we'll have lots of people in from across the region. I'm really excited. So we've got our NC Legal Aid Fair Housing Project, who are presenters today. I'm really excited that we're able to have them join us from Raleigh and be willing to help us with this. Fair housing is a very critical issue, especially in our housing market, and want to make sure that everybody understands what their rights are for the protected classes and are empowered with this education. So it's really important that everybody understands this. So I'm thrilled. We've got in this audience everything from landlords to our local governments to our grantees who receive federal funding. So it's a really nice mix of people. On the housekeeping side, the bathrooms are straight out the back. There's also a water fountain there where you can fill your water bottle. If everybody would take a minute and make sure their cell phones are turned off so we don't have that interruption, that would be really great and appreciated. All right, our presenters today from the Fair Housing Project of NC Legal Aid out of Raleigh and Durham. We have Lauren Brazil, who is our co-director and managing attorney for Legal Aid of North Carolina Fair Housing Project. She has represented victims of housing discrimination across the state in fair housing administrative proceedings before the U.S. Department of Housing and Urban Development and state and local administrative agencies, as well as in state and federal court. Nice depth of experience here. She's presented at fair housing seminars for housing consumers, advocates, attorneys, and housing providers. She is a heritage Spanish speaker and has worked with Spanish-speaking clients and communities across North Carolina. She's a member of the North Carolina State Bar, earning her undergraduate in psychology at Lehigh University and her JD at Temple University School of Law. Lauren, thank you so much for being here. And Hope Williams, supervising attorney with Legal Aid of North Carolina Fair Housing Project. She is bringing us the expertise in regards to victims of housing discrimination across the state. She's worked at Legal Aid since 2006 and previously was a staff attorney at Texas Rio Grande Legal Aid. Before joining the Fair Housing Project, Hope handled special education cases for students in public schools and immigration cases for victims of domestic violence and trafficking. She spent several years at Legal Aid's centralized intake unit, where she advised clients in a wide range of civil law matters and supervised Legal Aid's fair housing intake and advice cases. She graduated from the University of Texas School of Law and got her undergraduate degree in history at University of North Carolina at Chapel Hill. So welcome to Lauren and Hope. And just so everybody knows, please hold your questions to the end. We will have a Q&A session with a microphone, make sure everybody gets their questions asked. Please know all questions are welcomed. You're probably not the only one who's thinking that. So please don't hesitate and share your questions. We have this great knowledge here that's willing to help us. And just one note, I'm excited to say that we are hoping that we can plan a session in the fall that will actually be held in Spanish. So I'm really excited about that, and we'll be getting that information out towards the end of summer. So thank you, everybody. Please welcome.
Thank you, Nancy. Thank you. Good morning, everyone. Good morning. Okay. So my name is Lauren Brazil. I am a co-director and a managing attorney of Legal Aid of North Carolina's Fair Housing Project. Thank you so much to the City of Asheville, Buncombe County, and Land of Sky for inviting us today, and thank you to all of you for being here. Legal Aid of North Carolina, we are a nonprofit law firm. We provide free legal services to North Carolinians on a variety of civil matters. The Fair Housing Project is a statewide access to justice project. We are based in Durham, but we assist victims of discrimination across the state. We are appreciative for the opportunity today. Because we are attorneys, we do have to give a disclosure that the information we're presenting today is for informational purposes only, and it is not legal advice. If you need legal advice, you could speak with me afterwards, and we can try to get you connected with an attorney. We welcome general questions at the end. And so then my first question is, who's in the audience today? Who's a government staff? All right. Who's a housing provider? Okay. Any advocates? Okay, great. Well, this is a great mixture. We have a little bit of variety of fair housing topics to talk about today, but we're going to start talking, here we go. We're going to really start with a brief history of the Federal Fair Housing Act, because when we talk about fair housing and housing discrimination and the obligations of recipients of federal funding to affirmatively further fair housing, we have to start with the history of discrimination and segregation. It is the underpinnings and the principles that underlie our federal fair housing laws. And so we start by recognizing that for many years, discrimination was legal and affected many areas of daily life, including housing. And so, has anyone heard of sundown towns? Oh, that's good, right? Okay, so sundown towns were communities that were integrated, but after dark, only white people were allowed within the city limits. People of color were forced to leave the town, and if they remained, they faced threats and violence and intimidation. These were in the 1890s. How about this photo that you see where it says, fleeing from Forsyth, right? So this Forsyth County, Georgia, in 1912, when the African-American population dropped from over 1,000 to 0 and remained that way for 80 years. The picture on the top right of your screen is segregationist protesters preparing to attack a civil rights march in January 1987. And so this is part of the backdrop to the Fair Housing Act. How about restrictive covenants? Sort of restrictive covenants, right? So these were considered maybe a less visible way of discriminating. These were agreements in deeds that restricted subsequent owners of property, right? Based on race, religion, or national origin. These restrictive covenants were initially required in order to get FHA funding and mortgage loans. They have been found to be unconstitutional, but you still see them. If you go to the Register of Deeds, you can still see the racially restrictive covenants that are there. There is a program in Wake County right now where they are going back through the old records and trying to identify the racially restrictive covenants and provide context around them because they continue to exist in our databases. And so the vestiges of discrimination continue. How about racial steering? Everyone's heard of racial steering? Racial steering was a practice where real estate agents would recommend properties based on the racial composition of the community or of the individual seeking housing. The National Association of Realtors required its agents to segregate communities up until the 1950s. Of course, the Code of Ethics for the National Association of Realtors has been updated to reflect the anti-discrimination provisions of the Fair Housing Act. But again, when we think about segregation, right, and the history of discrimination, it is part of the reason why maps tend to look like this. Has everyone heard of redlining? Redlining was a practice where financial institutions would discriminate against prospective home buyers based on the racial makeup of where the home was. And so red areas were literally areas where lenders and insurers would not lend to people buying in those communities. And then green is where they would lend, right? These are Homeowners Loan Corporation maps. This one is for Asheville. And then if you click through, they are on the University of Richmond website. You can actually see the actual clarifying remarks that were included in the redlined maps and then the attached documents to them, right? And so some of these clarifying remarks, right, under detrimental influences, it says here, Negro settlement in the area, sanitarium for those suffering nervous ailment located on a road, Caledonia Road, smoke from the railroad, right? And so they identified race as being part of the reason why they would not lend or insure properties in that area. I thought this was really interesting. This is a little pocket of red surrounded by blue, and then you can see what it says under the clarifying remarks. This is a very cheap area, a very cheap Negro area, but all but North End being in Valley, mountains in east, west, and south on which white people live. In 1968, President Johnson established the Kerner Commission to examine the civil rights riots that were happening across the country. And it was an 8-member commission that ultimately issued a report that found that our nation is moving towards two societies, one black, one white, separate and unequal. In April of 1968, Dr. King was assassinated, and 7 days later, the Federal Fair Housing Act was passed. Dr. King's assassination is what created the political power in order to pass the Federal Fair Housing Act. There is a documentary, it's short, it's about 8 minutes. It's called 7 Days. It was produced by the National Fair Housing Alliance that has original video from that time and that talks about the history and how the Federal Fair Housing Act was passed, and it's excellent. When the Fair Housing Act was passed, it prohibited discrimination in the rental and sale and provision of housing, but there were really two goals. Remember, it wasn't just about not discriminating, it was about promoting residential integration to try to end the segregated housing patterns that had developed through the legal forms of discrimination. And so when the Fair Housing Act was passed, in order to effectuate that goal, it imposed an obligation on HUD to affirmatively further fair housing. And I think the question that we always get when we talk about affirmatively furthering fair housing is, what does it mean? Right? Because it can be vague, and maybe people don't know what it means. And so what we do know, is that it means that we must administer programs in a manner that affirmatively furthers the policies of the Fair Housing Act. It means doing more than simply not discriminating. We must also work to end the discrimination and segregation. Affirmatively furthering fair housing includes a mandate to take action to undo historic patterns of segregation and other types of discrimination to give access to long denied opportunities. The Fair Housing Act explicitly requires HUD to affirmatively further fair housing, and Congress included that provision in order to recognize that where a person lives is inextricably tied to their educational, employment, and economic opportunities, access to clean water and sewer and services. And it requires that local governments and public housing authorities have a responsibility to combat the impact of laws and policies that discriminate against communities of colors, people with disabilities, and other people who are protected by the Fair Housing Act. And it does that by passing on those obligations, it's HUD's obligations, onto recipients of federal funding. And so grantees also have the obligation to affirmatively further fair housing, oftentimes as a condition of receiving some form of HUD funding, like CDBG funding or ESG or NSP home. So grantees certify each year that they are taking actions to affirmatively further fair housing. And that's the real part of it, is the certification that you're doing all this other work to AFFH. The obligation applies to public housing authorities, to local governments, and their sub-grantees and recipients. And, and so we'll continue to talk about what that means. I will just note, AFFH has been part of the Fair Housing Act for many, many years, but what it's meant is we've learned through regulations mostly. There was a regulation in 2015. It was the first AFFH regulation. That rule was rescinded in 2020. In 2021, the 2020 rule was rescinded, so it's gone back and forth. The current status is an interim final rule that restored most of the previous definitions and most of the certification requirements. So HUD grantees are now, and have been for the past few years, regularly certifying compliance with the AFFH requirements, which again means taking meaningful action to combat segregated and unequal access to housing. There is a proposed final rule that was published in 2023. There was a public comment period. It simplifies some parts, it adds other sections. It's not a final rule. It's not final. We don't know what the final rule will say, but this is sort of an idea of where HUD is seeing AFFH and those requirements. There are excellent resources on the HUD website. I think that AFFH rule guidebook that provides a lot of information about planning is really useful. It's about 250 pages. I would print it and read it. But what it really reviews is, AFFH is, a big part of it is doing analysis and planning and identifying barriers to equal housing opportunities, identifying the actions that we are going to take to try to overcome those barriers, and also identifying other ways that we are going to promote integrated communities to stop segregation and to transform ERACs, right, racially and ethnically concentrated areas of poverty, into areas of opportunity. We're going to go over some of the basics of fair housing law, and then we're going to talk a little bit about fair housing and zoning, which is, I think, one area where we really see how AFFH can be used in the development of affordable housing and in trying to achieve AFFH goals. So when we're talking about fair housing, and what I've talked about so far is primarily focused on the Federal Fair Housing Act. It is the primary federal civil rights law for our housing work. The state of North Carolina also has what has been deemed by HUD to be substantially equivalent, a North Carolina State Fair Housing Act. It provides similar protections and remedies, and what it really means is that there is a state agency that is authorized by HUD to accept housing discrimination complaints, investigate them, and attempt to reach a resolution to them. There are also a few local jurisdictions that have local fair housing ordinances that are also substantially equivalent. It's the city of Durham, Charlotte, Mecklenburg, Winston-Salem, Orange County, and Greensboro. In those jurisdictions, there are local agencies authorized by HUD to investigate fair housing complaints. But we also pull civil rights protections and obligations from other sources of law. So Title VI of the Civil Rights Act of 1964 can implicate language access requirements, right? And then the Americans with Disabilities Act of 1990 provides protections for people with disabilities in areas of public accommodation, but that can also include certain parts of a housing complex, like the leasing office. Section 504 of the Rehabilitation Act, we'll talk about this afternoon. It really comes into play in terms of reasonable modifications when it's a recipient of federal funding. Ordinarily, the individual with a disability would pay for a reasonable modification. When Section 504 applies, the housing provider will pay for the modifications. And then Section 109 of the Housing and Community Development Act of 1974 comes into play with CDBG funds in particular, and can come into play with environmental justice type fair housing claims, which we'll talk about today. So the Fair Housing Act uses the term dwellings, but it really will apply to almost any residential unit available for sale or rental, so houses, apartments, condominiums, shelters, group homes, migrant housing, assisted living, long-term transient housing can be subject to the Fair Housing Act, and vacant land where housing can be built is also subject to fair housing laws. Almost anyone that is involved in the operation of housing is going to have to comply with the fair housing laws and the various names that we give to these folks, whether it's the owner of the property or a landlord, the manager, the management company, real estate agencies, lenders, banks, insurance companies, local governments and agencies, HOAs and condo boards. Sometimes neighbors are even need to comply with the Fair Housing Act. We've had a tenant-on-tenant race harassment case out of the Eastern District of North Carolina a few years ago, where the housing provider knew of the racial harassment and did nothing to stop it, and was ultimately held liable for the failure to stop the race harassment. It's going to apply to the rental and sale of housing, lending and insurance, but also access to municipal services, zoning, statements and advertising. And we will just note that it applies to subsidized housing as well as to private housing. So when we talk about discrimination under the Fair Housing Act, we're talking about conduct that treats someone differently because of their membership in a protected class. And so there are 7 protected classes under the Federal Fair Housing Act. When the Fair Housing Act was first passed in 1968, the first 4 were part of the original act: race, color, national origin, and religion, right? Race protects all races. Color of skin we usually think of as color within a particular racial group. If someone is being denied housing because they are a dark-skinned Latino or a light-skinned African American, color of skin within a particular racial group. National origin, generally thought of as ancestry or place of birth, but it's important to remember that someone's national origin could be identified in a variety of different ways, right? The language somebody speaks, whether or not they speak English with an accent. Even the food someone cooks can indicate to a housing provider that they are of a different national origin. And then religion protects all religion. It protects someone's right not to practice a religion. And so those were the 4 original protected classes. In 1974, sex was added as a protected class, and it was originally added and thought of in terms of pregnancy and financial discrimination, lenders that required women to agree to go back to work after having a baby, right? That was what part of what pushed the addition of sex. But since then, we've learned what else constitutes sex discrimination, right? And so under the Fair Housing Act, sex harassment in housing is sex discrimination, right? The Fair Housing Act prohibits discrimination because of sexual orientation and gender identity. And because about 80% of survivors of domestic violence across the country are women, when housing providers discriminate against survivors of domestic violence because of their status as a survivor of domestic violence, it can also violate the Fair Housing Act. In 1988, familial status was added as a protected class that prohibits discrimination against against families with children under the age of 18. Where we see this come up is related to occupancy restrictions, so 2 people per bedroom. We hear that a lot without taking into consideration the size and configuration of the unit can raise fair housing concerns. There are situations where there's very large units where they will have a large bedroom and it should be more than 2 people per bedroom. We've had cases where we've represented parents with a 1-year-old who were trying to rent a 1-bedroom unit. They room shared with their baby, and they were told they needed a more expensive 2-bedroom unit, right? And so we filed a HUD complaint based on that because they failed to consider the size and configuration of the unit, and that can be a form of housing discrimination. Also, restrictions on where minors can go on the property. We've seen cases that no kids can be out after dark, after 9 p.m. Well, that means a teenager, right, can't bring out the garbage to the curb, right? That's overly restrictive. Or we've had a few cases involving pool restrictions, right? Anyone under the age of 18 has to be accompanied by an adult to a pool. That is an overly restrictive policy that can be discriminatory under the Fair Housing Act. So that's the familial status category. It's really a unique part of the Fair Housing laws. The final part of the Fair Housing Act, of the Federal Fair Housing Act, are the protections for people with disabilities. And when Congress amended the Fair Housing Act to prohibit discrimination against people with disabilities, it affirmatively recognized that sometimes when you treat everybody the same, even that people with disabilities are still excluded from housing. Well, what do I mean? So if you have an apartment complex that has 3 steps to get up into the leasing office, everybody's treated the same. Everybody has to climb those same 3 steps to get up into that leasing office. But a person who uses a wheelchair may not be able to ever enter that office to even find out about the availability of units. And so Congress recognized that and required housing providers to make reasonable accommodations to policies and rules and reasonable modifications, physical changes to the structure so it is accessible for people with disabilities. The final section is unique to our North Carolina State Fair Housing Act, and it has to do with the siting and permitting of affordable housing. And I will talk about it in a minute. I do want to note the most common type of complaint that is filed with HUD in the state of North Carolina over the last 10 years has consistently been disability complaints. If you go back like 20 years, it used to be race and then disability. The last 10 years, we've gone we've switched disability and then race. But since COVID, and this is a new chart that I don't think Nancy has seen yet, we see race and disability complaint filings both increasing, right? So we are seeing changes in those patterns. Okay, so the affordable housing provision. Under our State Fair Housing Act, it is an unlawful discriminatory housing practice to discriminate in land use decisions or in the permitting of development because the development contains affordable housing. So government bodies involved in land use planning and regulation cannot refuse to approve housing proposals because they include affordable housing. And so we know that it includes zoning board decisions, planning boards, county commissioners, and municipal councils. This probably also applies to utilities and highway and other transportation considerations. But really, city councils and planning departments that are considering housing proposals cannot deny that proposal generally because of the fact that it has affordable housing. Now, there is a caveat and an exception, and in a lot of ways our laws have the law, the exception, and then the exception to the exception, right? So if the proposal is already located in an area where there is a lot of affordable housing, right, then the city council can deny it in that place, in that situation, right? Because there's a possibility that if you put all of your affordable housing in one community, it could perpetuate segregation, right? And so this is some flexibility that the law allows to prevent high concentrations of affordable housing. Now, there is no definition of high concentrations in the State Fair Housing Act, but we can look at HUD data about where the property is and what the demographics are of that area to try to determine if it would be contributing to segregated housing patterns or if the property is being proposed for a high opportunity area or an area with a lot of resources and assets. So how does this work in practice? Okay, so what it doesn't mean is that every affordable housing proposal has to be approved, right? It doesn't mean that. But it does mean that you can't deny it just because it has affordable housing. It also doesn't mean that landlords have to accept Section 8 housing choice vouchers. In 2014, the Fair Housing Project represented an affordable housing developer who had applied to build a 56 senior affordable housing community in the village of Pinehurst, North Carolina. Everyone familiar with Pinehurst. They play a lot of golf there. So the proposal was denied because it had affordable housing. That was the reason that was given during the city council meetings. And even though the planning department had recommended to approval, the city council still denied it. And so we filed a administrative complaint with HUD alleging race discrimination as well as the affordable housing protected class provision. There is now senior affordable housing in Pinehurst, North Carolina. As a result of that litigation, it was built. And so this is a really unique, thank you, this is exciting. It's a really unique part of our fair housing laws, and it's one of our big tools in the toolbox. I think Vermont has tried to do something similar, and so we'll see if more states try to adopt that approach. I've mentioned this a few times, but just so it's clear, zoning boards, cities, and other government agencies, zoning decisions and practices that have the effect of limiting housing choice are prohibited under the Fair Housing Act. It includes intentional discrimination, disparate treatment. It includes policies that have a disparate impact, that disproportionately deny housing opportunities to members of a protected class. It can also arise in the context of reasonable accommodations, particularly related to group homes, and Hope will talk about that in a few minutes. And then statements that indicate a preference, right? So when that city council member denied the Pinehurst zoning approval and said, we don't want affordable housing, right? That was a discriminatory statement under the fair housing laws. So when we are considering fair housing and zoning and how we prove it, we are looking to whether the consequences of the action bear more heavily on one protected class than other groups. We look at the historical background of the action, the sequence of events leading up to the actions, any departures from normal procedural processes or substantive criteria, additional requirements being imposed on just the affordable housing projects can raise fair housing issues, and then the overall administrative history. But it can arise related to the siting of affordable housing, access to municipal services, the siting of unwanted land uses, group homes, and then nuisance and crime-free ordinances. There is a joint statement from HUD and DOJ that covers local land use laws in the Fair Housing Act. I will briefly talk about nuisance and crime-free ordinances. There is a memo from HUD's Office of General Counsel about how these ordinances can violate the Fair Housing Act, and specifically notes that it is the obligation of recipients of federal funding to consider this guidance in light of AFFH. And the specifics for these types of ordinances can vary, but ultimately they are labeling certain conduct as a nuisance and requiring a housing provider to abate the nuisance, right? And so what happens is, the way a lot of these were designed, is that the landlord would have to abate a nuisance, and that nuisance includes repeated excessive 911 calls to the police, okay? But in many jurisdictions, the largest number of calls that police get are related to domestic violence. And nationwide, about 80% of DV survivors are women. And so these nuisance ordinances that require landlords to evict survivors of domestic violence who call the police for assistance with domestic violence can violate the fair housing laws. Kennedy v. City of Zanesville is a case that I wanted to talk to you all about today that was brought. This is a case out of Ohio, so not North Carolina, but I think it tells a really interesting story. So in 2005, 67 residents from Coal Run, Ohio, filed a federal civil rights complaint. They were represented by Relman Colfax, which is a preeminent civil rights firm out of DC, and they partnered with a demographer and expert out of Cedar Grove, North Carolina, for this case. In this case, the residents alleged that the city and the county and the water authority had illegally denied water services to the Coal Run community, the one predominantly black community in an almost all-white county, denied them water services for more than 50 years. And you will see, so here is Coal Run. This is Muskingum County, the city of Zanesville. Coal Run is this little neighborhood that runs right along the side of the city limits. It is also located about a mile from the water plant. Their requests for water service were denied. They were forced to haul water from that city plant, collect rainwater, and store it in cisterns. That's how they lived for 50 years. There was a lot of evidence in this case. It was 3 years, a very long trial, and it was a lot of experts involved. But there was one thing that tended to uncomplicate things, and that was the maps that were done by the Cedar Grove Institute for Sustainable Communities. And one of the lead attorneys who was interviewed years later after that case said, we could articulate the case in words, but when you'd put up the maps, they'd stop listening to you and look at them as if to say, is this really possible? And so I will show you the maps and the story that they told. So Coal Run neighborhood is this little community here. You see the water plant. The blue lines are where the water service was. And you can see how the water service extended all throughout the county, right? So this is the Coal Run neighborhood where there was and where there wasn't water. So the gray is there's no water, there's just roadways. The blue are the water lines. These are where the houses are. The houses that are blue have access to water. The houses that are gray do not have access to water. Here's the race of the residents. The houses that are white have access to water. The houses that are black do not. They went to trial, and the jury found for the plaintiffs, the Coal Run community, and awarded close to $11 million in damages. In North Carolina, the UNC Center for Civil Rights in 2013 did a study, a state of exclusion, that looked at a variety of different things. But one of the sections was the proximity of clusters of Black and Latino communities and how close they are to polluting sites and EPA monitored sites in particular, solid waste. There were two key findings that came out of that report. So residents in majority Black clusters are twice as likely to live within 1 mile of a solid waste facility. Almost 25% of North Carolinians live within 1 mile of an EPA registered polluter, but 41% of residents of Latino clusters and 44% of residents of Black clusters live within a mile, right? So Black and Latino communities are disproportionately located within a mile to polluting sites, okay? We are planning an update to that 10-year update to that report, hopefully by the end of this year. But it raises this intersection, and I think if you've been following HUD for the past few years, you see more of an emphasis on environmental justice and fair housing and affirmatively furthering fair housing and how all of these things work together in our planning and community development, right? And so Title VI, I mentioned earlier, it prohibits discrimination in federal funding based on race, color, and national origin. Section 109 is specific provisions related to CDBG activities. So those are two additional sources of law that we consider when we are looking at these issues. And they have specific regulations that prohibit recipients from discriminating when they are citing unwanted land uses. And that recipients have an obligation to take reasonable action to overcome the consequences of prior discriminatory practices and to accomplish the purposes of Title VI, similar to Title VII, which is the Fair Housing Act, Title VIII, which is the Fair Housing Act. How did that play out in North Carolina? So in 2011, there was a complaint filed, a state Fair Housing Act complaint filed on behalf of the Royal Oak Concerned Citizens Association, ROCA, the Fair Housing Project, and the UNC Center for Civil Rights co-counseled that case, and it alleged a pattern and practice of race discrimination by Brunswick County, North Carolina, that culminated in their decision to rezone property in their community, in the ROCA community, to expand a landfill. Here's the ROCA community and where the landfill was going to be expanded. The red areas are the predominantly Black areas, and the green, the light green is the existing landfill, and the dark green is the new proposed landfill. The landfill was not expanded as a result of the litigation. All right, I'm going to pass it over to Hope, who's going to talk about disability discrimination and group homes. Thank you.
Thank you, Lauren, and thank you all for being here today. I'm Hope Williams. I work with Lauren at the Fair Housing Project. And as Lauren said earlier, the biggest number of complaints that are made, discrimination complaints, are based on disability. So we do like to focus on that specifically because they come up a lot. And so when we're talking about the law, we need to know what the definition is. The law defines different concepts, and the law defines what is a disability. And so under the Fair Housing Act, a disability is a physical or mental impairment which substantially limits one or more major life activity, or a record of such impairment, or a person being regarded as having such an impairment. And so it doesn't define specific diagnoses as disabilities. It's focused more on, does the person have an impairment, and how does that substantially limit their major life activities. And major life activities are walking, talking, learning, basically what you need to do to get through your daily life, daily activities, breathing, basic things, and how does it impact it. Some examples of disabilities: blindness or other visual impairments, deafness. Those are ones that you might see, you might identify when you're interacting with a person. Mobility impairments, but it can also include other disabilities that are not as obvious, such as mental illness, cognitive disabilities, AIDS or HIV positive. Alcoholism is considered a disability under the Fair Housing Act, as is former drug abuse, and that's important. It's not current drug use, but people who are in recovery from substance abuse are considered disabled under the Fair Housing Act, and that can be important when we're talking about group homes, because sometimes that is where some of the question is about whether that's a disability and how that applies. So when we're talking about protections for people with disabilities under the Fair Housing Act, you can't deny a person housing because of their disability. And sometimes we encounter situations where people are explicitly told that. But sometimes it's a little more subtle, where people are told, well, this isn't a good fit for you, or we don't know if you can get up and down those stairs, or, making the housing decision based on the perception of perhaps a property manager rather than the person with a disability who knows their own limitations. So imposing different terms and conditions, perhaps making somebody pay an extra deposit because they have a wheelchair, because there's an idea that the wheelchair might damage the walls. That would be a discriminatory terms and conditions. It can also be discriminatory to have neutral rules that disparately impact persons with disabilities. So for example, a landlord might have a rule that anyone who lives there has to have employment income. They have to be employed. And the rule is there because they want to make sure the person can pay rent. But sometimes people with disabilities have disability income. They're not employed. And so that rule would tend to discourage a person with a disability from applying for that housing because they're not employed and they wouldn't meet the requirements. So that would be a neutral rule that's designed to make sure you can pay the rent, that actually disparately impacts persons with disabilities. And these rules apply, it's not just the person who's named on the lease, but also other occupants of their household and people associated with the buyer and the renters. Other things that are prohibited under the Fair Housing Act are inquiries into the existence of a disability. Landlords shouldn't be asking tenants if they have a disability, what their disability is. We'll talk about reasonable accommodations in a second, where in that case, the person has to explain that they're asking for it because of a disability, but landlords should be very careful not to be asking those types of questions because that is considered discriminatory. And when I talk about the source of this information, HUD has a joint statement with the Department of Justice about reasonable accommodations that it's available on the HUD website. We link to it on our website. It's extremely helpful information. And the reason it's helpful is because HUD and the Department of Justice are the ones who are enforcing the Fair Housing Act. And so knowing what their position and how they understand reasonable accommodations to work is really important. And I refer to it all the time when I have cases, because every situation is a little bit different, and there's just a wealth of guidance in that guidance. So I suggest anytime you have these questions, pull up that joint statement, because you'll probably find the answer you're looking for. So another prohibited conduct under the Fair Housing Act is unlawful statements in advertising. In this day and age, fortunately, there's not as much explicitly discriminatory advertising that's out, but there sometimes is. Things on Craigslist or other online posting might suggest that a person with a disability shouldn't apply for housing, or the way things are worded. And as Lauren mentioned earlier, the Fair Housing Act applies to all housing. Sometimes people have an idea that federal law applies to subsidized housing only, but it applies to all housing, private and subsidized housing. So these rules are going to apply to anybody in any housing that's in the housing market, with some very limited exceptions. So some examples of things I mentioned: don't be asking about disability or diagnoses, or if you have a disability, but also asking questions like, can you live independently? Have you been in a drug rehab program? Those are questions that would be discriminatory under the Fair Housing Act. As Lauren mentioned earlier, there are also times when a landlord may have a duty to take affirmative steps to enable a person with a disability to have equal access to housing, and those are called reasonable accommodations and reasonable modifications. And the question comes up sometimes, well, if I'm treating them differently, then that's discriminatory. I thought the Fair Housing Act was about treating everybody equally. But what the Act says and what the guidance says is that sometimes to give those equal opportunities, if a person is not able to access or enjoy their housing on equal footing because of their disability, then a change needs to be made in the policies and how they're implemented as to that person, or the physical structure of a unit may need to be changed so a person can access it if that reason is because of their disability. So what's a reasonable accommodation? It's a change in a rule, policy, or a procedure that is necessary. It has to be necessary because of the person's disability, and it has to provide full and equal use and enjoyment of the property. Sometimes we get questions about, well, they didn't ask for it when they moved in, so do I have to grant it now? HUD guidance is very clear. A person can ask for a reasonable accommodation at any time during the application process, while they're already living there, and even when they're facing an eviction, if the reasonable accommodation would remove the basis for that eviction. And there's a case that discusses this very issue, where the court says that a reasonable accommodation is available up to the proverbial last minute, before that eviction happens, if granting that accommodation could remove the basis for the eviction. Reasonable accommodations can be requested by the tenant, and that's usually who is requesting those accommodations, but other people can request it on behalf of the person needing the accommodation. It could be a family member, a social worker. Of course, as attorneys, we are often asking for accommodations on behalf of our clients. Doctors can ask for them. It doesn't have to be from the tenant. Some examples of accommodations that come up. A person who has a mobility limitation might need a change in the parking rules. There might be a rule that it's first come, first served parking, no assigned parking spaces, but a person who has limited mobility may need a spot that's closer to their apartment because, it's a very different experience getting, across the parking lot for that person versus a person who doesn't have those mobility limitations. Changes to the way applications can be filled out. A lot of stuff is online now that might not be accessible to a person with a cognitive disability. Maybe making an exception that that person can call in and give their information over the phone to the property management staff. That could be an accommodation. Changing the due date of rent. People who get disability payments have no control over the date. They get it the same date every month, but the federal government spreads out those payments, and so they are not making them all at the beginning of the month, and so sometimes that timing can mean a person with a disability whose only income is that disability check is continually getting charged late fees because they don't even get their check until the 17th. So changing that due date can help with that. Changing leases, sometimes people might develop a disability that causes them not to be able to access a second floor apartment, allowing them to move without that transfer fee, how payments are made, check versus online, and then some more, timing of ending a lease early, live-in aids might be needed to be added to an apartment and not consider their income because they are a live-in aid. Terminating a tenancy due to poor housekeeping can be a situation where a person might have mobility limitations or mental health limitations that is impeding their ability to follow those rules, and maybe they need more time, or maybe they need additional advance and warning about when this is going to come up so they can comply with those rules. And another big one, and we'll be talking about this, we're doing an afternoon training here, assistance animals is a big one that comes up. But I did want to talk about zoning and reasonable accommodations. As Lauren talked about, HUD has issued guidance, HUD and the DOJ has issued joint guidance about land use decisions and the Fair Housing Act. And as you know, land use decisions are local decisions, but under the supremacy clause of our Constitution, they have to comply, these decisions and these ordinances have to comply with the federal law, including the Fair Housing Act. And so one of the areas where this comes up is with the need for reasonable accommodations in that process. And that was going to apply in situations where where a decision is being made about housing for persons with disabilities. So some examples of discrimination that can come up in zoning. We talked a little bit about, the Zanesville case and things where, decision about who's getting water. Those are examples of discrimination when we're talking about land use and decisions, but also denials of buildings and renovations, special use permits. So that's something that comes up where sometimes a group home, and the Fair Housing Act doesn't define group homes, but it's understood to be a home where there are a group of persons with disabilities residing there. They might be requesting that a single family home be used for a group home. And they might need a special permit for that, or they might need to do, there's usually rules about, how you use property. And, denying that because it's a group of persons with disabilities, that is going to be an example of intentional discrimination. Another example is moratoriums on certain types of facilities without justification. Other examples are limitations on geographical proximity. When you're placing group homes and that are based on community fears and ideas about property values. And to be honest, when you look at these cases and when they come up, it's usually a group is applying for these permits or going through the process to get this use, and the city may be in the process of approving it, and then the community finds out about it, and often based on unsubstantiated views about people with disabilities, they say, we don't want that in our neighborhood. Classic NIMBY, not in my backyard. They should need to go somewhere else. And when the city responds to that and denies it, there's usually a pretty clear connection between that action and a discriminatory consent or discriminatory intent. Even if the people who work for the city don't share those views, if they are responding to those views from the community and acting on them in that way, that can be intentional discrimination. And then treating group homes for people with disabilities different than a single family home, even when the group home meets the single family home definition. So most city ordinances have, a certain number of people are considered, a single family. And if you're letting another group of unrelated persons live there as a single family, but you tell the group home who has the same number of people living there, perhaps people who are in recovery and who are trying to live together, support each other in this recovery, that can be an example of discrimination that comes up in this context. Fire code provisions can be discriminatory if they're not being applied everywhere to the same type of housing. Supervision rules are something else that come up. Certificates of occupancy that are required but not for other types of homes. Requiring notice to neighbors where that's not required for other types of residential units. Those are all examples of discrimination. And these come from the guidance, but they also come from cases where courts have found this type of conduct to be discriminatory. Other examples that we see, dispersion requirements, saying they have to be spaced out in a certain way, can be discriminatory. There's the Fair Housing Act prohibits interference, coercion, or intimidation, and in this context, that can be the denial of special use permits, where the reason given for the denial is really pretext because they don't want persons with disability living there, or it can be citing the group homes for violations where these types of things are happening all over the place, but only the group home is being cited for it. So reasonable accommodations can come up in this context as well. So it may be that a group home needs an accommodation to the policy or the procedures that are in place to enable them to operate on equal footing. So some examples would be allowing a nursing home to operate in a mixed residential zone, waiving minimum side yard requirements, variances, allowing more people into like an 8-person home into a 6-person home. Usually you have to show it's necessary, so you have to show why you need that, and exceptions to dispersion requirements. And so there is an exception under the Fair Housing Act about direct threat. So the Fair Housing Act does not require a tenancy that would be a direct threat to the health or safety of other individuals or result in substantial damage to the property of others unless a reasonable accommodation could eliminate the threat. And so this comes up because a lot of times the people who are opposing perhaps a group home in their neighborhood, they perceive that this would create a threat to the community. People with these who are in recovery, they're going to be violent, but they cannot. And so it's important to know that this direct threat exception would not say, that's okay, you're saying that, you're right, they can't be here. That's not what this is saying. It has to be based on actual evidence that this particular group of people create a threat, and not just based on general perceptions that people who are in recovery might be a threat. And so that's really important. And HUD is very clear, and courts have upheld, that if there's a reasonable accommodation that could eliminate that threat, then that should be considered before you're denying that housing. So are there things that could be put in place to address what we have established is some kind of actual threat that pertains to this actual specific group of people? So that's important to keep in mind, that there is that exception, but you need to understand that it's not just a blanket permission to say, well, this might be a threat, so we don't have to approve it. Drug use, like I said earlier, current use of illegal substances is not considered a disability. So we just have a couple of examples, and these cases have come up around the country, and it can be very expensive when local governments do not comply with the Fair Housing Act. And there's examples where, and usually these cases are coming up where people are applying for permits or trying to site their group homes, and the city, often responding to community pressure, refuses to grant the permit, or in some cases they grant the permit and then they withdraw it, or they don't issue the certificate of occupancy, any number of things. And as you can see from these cases, it can be very expensive for these local governments when they don't comply with the Fair Housing Act. So that's why it's important to understand how these laws work and the parameters of them ahead of time, and make sure that you are complying when you're making these local decisions about placement of, in particular, group homes, as these specific cases address. So, did you want to? All right, thank you.
Do you hope? We're going to go into questions in a minute, but I think as we wrap up today's presentation, we just wanted to recognize that with AFFH, there's so much guidance from HUD on how we look at our communities, determining who lacks access, and how we identify tools and ways to address inequities and segregation. And we look at these things, but there are opportunities there, right? Like, there's no specific requirements. It's up to the local community, both the government staff and the actual people who live there, to form these solutions together, right? A big part of AFFH is community engagement and input, and making sure the community has a role in shaping the future. And so I think there are opportunities, and when you look at how broad the Fair Housing Act is and the different ways it can be applied, we can think creatively about how to address segregation and discrimination in our communities. There was one additional piece that I wanted to point out. It's not something that we are doing, it's not our program, but it's the National Fair Housing Alliance and the Mortgage Bankers Association that's announced a new toolkit for mortgage lenders interested in developing special purpose credit programs. It was launched in 2022, but these are ways to permit lenders to offer mortgage credit to economically and socially disadvantaged borrowers. It's a way for institutions to meet the needs of consumers. So it's a toolkit. There's a whole website about it, but it's something new that where we're seeing innovation and innovation being used to address inequities and promote fair housing. So, and now we can open it up to questions, and I think there's a microphone somewhere. I don't know if it's on.
city. I had questions about, I guess, the screening process for tenants, specifically about like criminal backgrounds. I'm just thinking about all the homeless people in our community. They generally have a long rap sheet. What's the regulations behind that?
Sure. So we're going to be going into more detail about criminal background screening in the afternoon session, but there is guidance from HUD, the Office of General Counsel from 2016, and then there was recent guidance in June of 2022 that talks about how the Fair Housing Act applies to tenant screening and the use of criminal background screening in the tenant eligibility process. HUD's latest, the 2022 memo, questions whether or not criminal background screening is even a good indicator of whether or not people would be a good tenant, whether a person would be a good tenant. I will note that there's oftentimes errors in those reports, and where we're seeing the law, both from the litigation side as well as the guidance from HUD, is encouraging housing providers to allow people to to request individualized assessments, right? So housing providers should evaluate the individual that is before them and not just the criminal background record. And so people should have an opportunity to present to a housing provider why any information about their criminal background, how long ago it occurred, the severity, what any mitigating circumstances around it. We've had a few cases over the past few years where that justice-involved individuals trying to get access to housing. There have been cases in North Carolina and across the country on that very topic. So there's two really good pieces of guidance from HUD, 2016 and 2022. They're on our website. Individualized assessments is where that is moving. And I don't know, yeah?
And just really quickly, within the next week or so, we are going to be putting out a guide that we have finalized about renting with a criminal record, explaining the HUD guidance about it, and it has a sample letter that people can use to ask for that individualized review. Because really what HUD is saying in their guidance is that the criminal background policies tend to be overly broad, which is going to tend to exclude people who are in protected classes, perhaps based on race, national origin, people with disabilities. And so landlords are tending to look at these background reports and being like, no, you don't qualify because of what is on that piece of paper. But HUD is saying you really need to be having these individualized review and look at the person in front of you and get more information about them to determine whether that criminal record is a basis to say, no, you wouldn't be a good tenant here. So look out for that, for that resource.
I have two questions. The first, I'm wondering, knowing that source of income is not a protected class on the federal or state level, I'd love for you to speak to how local communities can address that or prevent that. And then my second question is, do you all still do fair housing testing in the area, and are there ways to tap into that?
Yes, okay. So your first question about source of income, you are correct. Source of income is not a protected class under the Federal Fair Housing Act or in the state of North Carolina. There is one caveat to that. There is an IRS regulation that requires low-income housing tax credit properties to accept Section 8 housing choice vouchers. I think the other area where we see some potential for related to voucher type discrimination is if a housing provider will accept a Section 8 voucher but not a HOPWA voucher, for example, which is a voucher specifically for people with AIDS, right? So discriminating, that would be more of a disability type claim. I think there are also TCL vouchers that are specific, so refusing one type of voucher that is designed for people with disabilities, but rejecting those but accepting others could be a difference in treatment. There have been some, I think the city of Charlotte did it. They have some provision in their ordinance related to source of income and in properties that have received city funding for their development, but it's been very limited. And that is status of source of income in North Carolina. Fair housing testing. We do fair housing testing across the state. If you are interested in fair housing testing, we have a section on our website, fairhousingnc.org. Fair housing testing is a way to try to investigate allegations of discrimination. It's almost like secret shopping. We have trained fair housing testers. We follow a HUD methodology when we do fair housing testing. Testers are paid a small stipend, but they go out and collect information about the availability of units and report back to us. But if you're interested in fair housing testing, we have a section on our website where you can contact us about finding out how to become a tester. Thank you.
Hi, my name is Kelvin Anderson. Thank you to both of you all. It's been very helpful, the information you've shared. I'm a housing choice voucher recipient, possessor, and if I have been discriminated against, and some of the information that you shared as far as the community engagement, maybe public service announcements as educational tools to prevent, those type of occurrences. I'm not saying that they have not been used in my particular experience, but how would I go about addressing a matter where, when I try to port, the portability aspect of the voucher and the initial contact with the person who was, the coordinator in that particular area, Goldsboro, to be specific, the initial communication was, relatively positive, if you, to describe it, but the communications thereafter were just severed, no response, absolutely, after multiple calls, and I just sort of just washed my hand and just said, well, I guess it's God's will that I'm not there. But what's the steps that can be taken?
So people who are seeking legal advice can contact our helpline if people want advice about what to do in a particular situation that they are facing. We have a toll-free number, and it's on the screen, 855-797-3247, if people want advice about what to do in a situation. To exercise your fair housing rights, you can file an administrative fair housing complaint with the U.S. Department of Housing and Urban Development. You have 1 year from the last act of discrimination to file that complaint. There's an online portal. It asks you a few questions about who discriminated against you, why you believe you were discriminated against. Make sure you tie it to your protected class. And that starts a complaint process. Those are I think those would be the main two ways. Sometimes it's hard to know whether it's discrimination or if it's just someone who's just not good at their job, right? And it can be hard to know. So testing can be a tool used to try to uncover whether or not it was discrimination, right? It helps you look at patterns. And then the other part is that if you do file a complaint with HUD, they assign an investigator who will request information from you and will request information from the housing provider, and they try to make a determination of whether or not they believe that reasonable cause exists that discrimination did or did not occur. But that's the complaint process. I'm not sure if there's any other ways to contact like HUD, if there's a public housing agency. I think the Fair Housing Complaint Avenue can be very useful.
Thank you.
Yeah.
Hi, good morning. My name is Reed. I'm a landlord in town. I had a brief question for you. I know you mentioned you'd probably be covering some more this afternoon about assistance animals. One of the things I've seen in forums online is where people have a dangerous breed animal and they say, oh, just go online and get a doctor's note from a doctor they've never met, or, and so I have a potential applicant bring me that to get around to navigate around a barrier from my insurance company or something like that. I don't mind that they have the animal. I just don't want to be liable because I didn't do my due diligence or whatnot. Where's the line between the disability, emotional support, and how do we, as a landlord, how do I protect myself and not get into rock and a hard place?
Sure. Good question. And we will be talking more about emotional support animals and assistance animals later, and specifically about internet documentation. So there is a very long, it's a comprehensive piece of guidance from HUD. 2020, I think, is the year. It's on our website, and it will go through step by step what questions a housing provider should or should not ask, or can and cannot ask, when evaluating a request for a service animal and when it's a request for an assistance animal or an emotional support animal. In regards to the internet documentation, it's been a problem. And what HUD has said is that the internet documentation alone is generally not enough to establish that somebody has a disability-related need for an emotional support animal, like a non-obvious disability. That doesn't mean that they don't have a disability or a disability-related need. It's that that alone is not enough. And I will say we've had situations where, for example, we had a client who could not get into the VA for a new appointment to get an updated letter while they were moving, and that's what they did. They went online and they got that interim certificate while they were waiting for that VA appointment, right? And so we knew that that certificate wasn't going to be enough, but they had an old letter and there's a pending appointment coming, right? So generally what we recommend is that you want to get a letter from someone with knowledge, someone who's treating that person and has some sort of relationship with them. But the HUD guidance will go through that in more detail. In terms of the breed restrictions, so under the Fair Housing Act, breed restrictions do not apply to service and assistance animals. In terms of the insurance companies must make reasonable accommodations to their policies to ensure that people with disabilities, despite the restricted breeds, can live in their home, and they should offer you similar rates. And if they don't, that insurance company could be liable under the Fair Housing Act as well. So,
Thank you.
okay.
Hi, thank you. I kind of have 2.5 questions. The half one is I didn't know there was an afternoon session. What time does it start?
1 o'clock, I think. Is that right?
Perfect. Thank you. All right. So I wanted to know. So at the very end, you talked about like the idea of community engagement and input. Now that's helpful to get the word out. Do you have any information, or has the idea of residence councils and fair housing, has that come across your desk or your thought processes?
Interesting. Not necessarily. I know the public housing authorities have resident councils, but not on a broader level. I like that idea. That's interesting.
Okay.
You know, the community engagement and participation part is a really big part of AFFH, and even when you look at the proposed rule, even though it's not final, it really focuses and emphasizes that community engagement part. So, you know, I think there's a variety of ways to meet that goal.
I'm thinking more in the area of interference with residence councils so that people can't advocate for themselves. So I'll follow up on that.
Yeah, that's interesting. Okay.
And the other one, earlier in the presentation under the civil rights, you mentioned tenant-on-tenant issues.
Yeah.
And can you give me a little, maybe a citation or a way to that I can
Yeah,
further-
so the case out of the Eastern District is Harris. I forget the full name. I can get it for you. It's the Harrises.
Harris?
Yeah, is the last name of the plaintiffs.
Do you know what year?
Yeah, it just settled in 2022 and 2023. The case lasted for about 5 years in litigation. It is a tenant-on-tenant race harassment case. So our clients were an elderly black couple who lived in eastern North Carolina. They lived in a duplex, and the person that lived like in the part attached to them was white. They were an elderly black couple, and they were subjected to constant race harassment, racial slurs, through the wall, banging, threats, intimidation. They were literally chased out of their home. They went to everyone they could think of to get help with the tenant, and no one could help them until they were finally chased out, and they found their way to us. And so there was a rule in 2016 that HUD put out about harassment. Harassment applies to all protected classes. The most common that we see is sex harassment, but this was a race harassment case. Some of the people that they went to during that process to try to get help included the owner of the property and their agent, right? And so they had knowledge, the agent had knowledge of the race harassment. They had the ability to do something about it, right? Make that harassing tenant stop. And instead, and they didn't, what they did about it is that they sought to evict our clients, the victims of the harassment, Vanderburg. It came to me, Harris v. Vanderburg. And so that case, we filed that case against the owner of the property, the management company, and the individual tenant. The case settled for about $500,000 in damages for the family that was discriminated against. The Department of Justice actually brought criminal fair housing charges against the individual. He was convicted and served 28 months in jail for his criminal violations of the Fair Housing Act, which is unique and does not happen very often. But yeah, so housing providers under the 2016 harassment and vicarious liability rules, the housing provider can be held liable for the discriminatory conduct of its tenants when it has knowledge of the discriminatory conduct, has the ability to do something about it, and they fail to do so.
Thank you very much.
Yeah.
Thanks for being here again.
Thank you.
Short question. Are public housing authorities allowed to restrict where housing choice vouchers are allowed to be used?
Like within their own jurisdiction? Not that I'm aware of.
Okay. That's all.
Interesting.
Thank you.
Interesting, though.
Wonderful questions. Thank you, everybody, for being here. Thank you.
Thank
to
you all.
Lauren. Yes. Thank you. I just want to add a couple of things. The Buncombe County's affordable housing website, we have a fair housing link. It shows our fair housing plan, which goes through 2026. We have activities in there. It's got our plan. We also have links. Buncombe County has a non-discrimination ordinance, so that's also a means in that. So it's a different means, but it means you're just working through where we will, Buncombe County will try to assist and get you to the right place that can assist you if there are claims. So thank you again, everybody, for coming. You're welcome for the afternoon. We have plenty of room. Please tell anybody you know, and thank you again.
We have program evaluations that we would be grateful if y'all could complete. I think Hope has them over there, but it helps with our HUD funding, so thank you.